people say, and I always say, all land use is ultimately local. And so I could stand up here for the rest of the day and bore you with specific zoning regulations from all different places around the state and around the country. But that wouldn't do you a lot of good other than to give you a list of what's out there, because again, all land use is local. And so what I want to try and do is sort of set the stage for this discussion with some fundamentals, with some principles that should guide all land use decisions and all land use regulation. And as John talked about with the county officials session, we didn't do a lot of talking and they asked a lot of questions, and I think that made it a great session. So I want to try and be fairly brief here, and I do hope that you all will have questions and we can have a great dialogue. So with that, where does land use law really come from, right? Where does local government get the power to tell people what they can and cannot do with their private property? Fundamentally, it comes from nuisance prevention and the police power that local governments have to regulate the public health, safety, welfare, and morals. With the inclusion of morals there, I'm using the old phrase. A lot of state statutes don't include morals anymore, but sometimes they do. And public health really is where land use regulation started from. Land use regulations, though, should really be the minimum intrusion necessary to protect the public health, safety, welfare, and morals, right? Land use regulation is an intrusion on people's private property rights. And so that should be the minimum necessary, right? Don't overzone, don't overregulate, and balance that intrusion with that protection of the public and the protection of property rights. Dillon's rule, very old case law here, but very fundamental to all this. Municipalities only have the powers that the state delegates to them, and that goes for cities and for counties. So keep that in mind as well. Again, really a limitation on the ability to regulate. It's really not sort of a free, open situation. It's only what the state has given you. Now, in the vein, though, of all land use being local, what most state laws on planning and zoning do is they regulate procedure. There are very few substantive zoning requirements in state law. They don't tell you how tall a building can be, whether you need to have, residential over here and commercial over here. It's really pretty much due process. They leave the substance of it to the municipalities. So who's involved in a zoning matter? You have a zoning administrator, and sometimes in rural Nebraska, of course, that person is also the highway superintendent and the weed superintendent, and they're very busy people. You have a planning commission, who are typically appointed people. You have a board of adjustment or a zoning board of appeals that has a quasi-judicial kind of a role. And then you have an elected governing body that makes decisions as well. I want to go back to this. I may have another slide on it, but I want to talk about the Planning Commission a little bit and why we have planning commissions. Planning commissions, again, are appointed officials, but they're there to really lend their expertise. Their only focus is planning and zoning, whereas that county commissioner or that city council member has to deal with budgets and all other matters that an elected official has to deal with, where a planning commissioner is appointed for the sole purpose of dealing with planning and zoning matters. And I think that's really important. Now, does the city council have to follow the planning commission's recommendation? No, of course not. They're typically a recommending body, but they really do have a special level of expertise, and I think sometimes that gets overlooked, but that's a really important feature, and they are authorized under state law for that very purpose. So one of the things that we have in Nebraska that I think is really unique, I started my career in California, and when I came here and I discovered that we have different sets of statutes for land use and zoning for different sizes of communities. And I always say to Trevor Fitzgerald, as the legal counsel for the Urban Affairs Committee at the legislature, and I say, Trevor, we need to combine all of these statutes into one. And he says, you're nuts, we're never doing that. So that may be my retirement project. But I bring it up because it's important, because there are subtle, sometimes, differences in the procedures that apply to different cities and to counties. There's a chapter for counties as well. And so be aware of that. You can't go apply the state laws that apply to Omaha or Lincoln necessarily to Holt County or whatever it might be. Zoning standards, and again, this, the title of the session is basics, and this is basic, but it's really important, and it gets overlooked, I think, sometimes, and so I want to make sure and touch on it. Clear, understandable standards. I think the developers in the room would agree with me that sometimes you almost don't even care what the rules are, as long as they're clear and rational and understandable and applied in an even-handed, consistent way, so that you know what's coming. Uncertainty is a developer's worst friend. And so clear, understandable, logical standards. Definitions are key. I can't tell you how many times I've been in a zoning ordinance or a zoning regulation, and there's a term there that's not defined, right? It's a simple thing, but without that term being defined, that regulation really doesn't work very well anymore. So definitions are really, really important. And start with the definitions a lot of times too. When you're first kind of getting into a zoning regulation or a new zoning ordinance, take a look at the overall structure of the thing and look through the definitions. You might find a lot of your answers in the definitions, and the rest of the analysis a lot of times gets pretty easy after you understand the definitions and you know what's in the definitions. Have a why for each requirement. Again, fairly fundamental, but you see requirements all the time and you say, well, why is that there? And the zoning administrator or the city councilor or somebody will say, well, gee, I don't know. Or we copied it from another county, right? Or we got it from another place. Why are each of these regulations in here? And this is the wind and solar conference, of course. You look at a lot of wind zoning regulations and they talk about an aggregate project. And it's sort of like, well, of course it's an aggregate project, or it's one project, right? I mean, I think some of those came about in the era of maybe one or two turbine projects. They contain standards and regulations in them that don't really have a why to them. They don't really make sense in the current context. And they cause problems for the people trying to use those regulations, because then the why isn't clear and the application of it is not clear. Be careful copying and pasting. And consider streamlining regulations. We had a long, what do I want to call it, process with Lancaster County about 3 years ago with their wind zoning regulations. And the only thing I'll say in this setting about those zoning regulations is that they are very short. They're about 2 pages long. And I commend Lancaster County for that. It was a years-long or more than a year-long process to come up with that 2 or 3 pages of regulations. And again, I give them a lot of credit for keeping it fairly simple and to the point. I disagree with some of the substance of it, but definitely give them credit for streamlining. So we talked about the Planning Commission. Again, Planning Commission is a really important part of the process, I think sometimes overlooked. And I think sometimes even city councils or county boards, elected officials, aren't entirely sure what the role of the Planning Commission is, other than it's a step along the way. And I think they lose out sometimes by not making use of that expertise. Again, that Planning Commission's only function is to focus on land use matters. So it's really a resource if you're an elected official. So due process is a very important part of this as well. I mentioned that really most state law on planning and zoning is about due process, right? And people have rights, right? Due process is to protect the right of the citizens to seek redress from their government in matters of land use and property. Again, we're fundamentally talking about property rights here, one of the most fundamental things in our American legal system. And land use regulation, though, gets funny in that respect, because it gives me the opportunity to try and at least tell John what he can do with his private property, right? But in our system of laws and regulations, I have a right to do that. John, though, also as the applicant for whatever zoning permit he might be seeking, has rights as well. And again, I think this is a thing that sometimes it requires absolutely a balance. And a lot of times it gets out of balance. Either you have a room full of angry neighbors and the city council is kind of going, well, gee, we got a room full of angry neighbors here, we got to do what they say. denying the applicant perhaps his or her right to some kind of land use approval. Or you maybe have an applicant who's pretty well connected and you have a room full of angry neighbors and they get ignored. Neither one of those are good things, regardless of which side you're on. Some of the best zoning outcomes, they can be painful, but they involve compromise and they involve the balance of those rights. I also have a bullet on there, litigation risk. Land use litigation was a lot more common when I worked in California, I can tell you that. It was good for the practicing lawyers, but maybe not for anybody else. Land use litigation, where somebody is challenging an approval and they do that successfully, much more often than not is on the process. A court's going to look and say, did you give the notice that the statute or the ordinance says you were supposed to give? No, you didn't. Go back and do it again. It's pretty simple. If I go and I challenge John's zoning permit because I don't like it, or I think that the tribunal poorly exercised its discretion, I've got a lot bigger uphill to climb. Again, land use is local. Courts tend to defer to local decision makers when it comes to substantive land use decisions. If that municipality says this is the noise limit we want to put on wind, and I go say, I don't like that noise limit, that's a tough one to win. If they didn't give notice of a hearing, or they didn't let people in the room who wanted to speak about the noise limit, that's a different thing. And that, from the applicant standpoint, is a challenge where you have a better chance. Now, for the elected and appointed officials and the folks who work in this area, right, it's kind of the reverse is true. Be really careful on the procedural part of it. Be careful also exercising your discretion. And I always say, show your work, right? If I go to a court and the court says, well, why did you make this decision? And they have the record of the proceeding before them, and there's nothing there connecting the decision to the facts that were before, let's say, the city council, the court doesn't understand why they made that decision, and that's a lot more likely to be successfully challenged. If there's a clear written record of findings saying, here's the regulations, here are the facts, here's how we applied these regulations to these facts, and here's why we came to the decision we did, and we find this, and we find that, and we find the other thing in reaching this decision, a court is going to look at that and say, well, I may or may not agree, but they clearly had a logical basis in fact and law for the decision that they made. And again, a court is really unlikely to disturb that. In another life, I do a lot of tax increment financing work and do these kind of things on tax increment finance. And the legislature this last year did its first sort of major overhaul of our community development law in quite a while. And one of the things, and I was part of a group that worked on that legislation, and one of the things that we put in there is a requirement for written findings. And some people, city administrators and zoning officials said, oh great, thanks a lot, now I just have one more thing to do. But I supported that regulation or that change to the statute because it's really important. It's how elected officials, again, who are imposing limitations on people's private property rights, document that. Or in that case, they're taking and dividing tax dollars for certain public purposes where the developer is going to take those tax dollars and build some infrastructure or what it might be. It really, in a way, it's only fair to ask the officials who are doing that to make a record of why they do that. And the findings don't have to be voluminous. They just connect, again, the facts and the evidence to the decision. Discretion. I've talked some about discretion. It is certainly present in land use decisions. And again, all land use is local, and the discretion is most present in the substantive land use decisions. There's not a ton of discretion on the procedure side, but it's also limited, right? Again, think about Dillon's rule, and think about the regulations that are there. I think sometimes you see, and it's not a fault of theirs, they're doing the best that they can, but you see an elected body make a decision based more on opinion than the facts and evidence before them. They have to some extent, they have that right. They have some discretion, but discretion certainly is not unfettered either. And again, I think this may be the third or fourth slide where I have the word balance. You need to balance those two things, right? Discretion, but what does the law tell us also? What do the regulations tell us? And that's only fair to the applicant and to the citizens in the room either supporting or opposing that application as well, right? I talked about they each have rights. You're trying to balance those rights. The fair way to balance those rights is to exercise discretion in a very careful, mindful, and somewhat limited way. So, talk quickly here about landowners' rights. This is the Wind and Solar Conference, after all. Really, really important, I think, to differentiate between participating landowners and non-participating landowners. To regulate participating landowners in a way that makes it very difficult for them to host a wind turbine or a solar panel on their project is really a significant intrusion into their property rights. Now, it's done for the purpose of sort of protecting their neighbors, but all land uses have externalities, right? Do I get to tell my next door neighbor that he can't have maple trees because those leaves all fall in my yard at this time of year? No, I really can't do that, right? Everybody, and hey, the good news is my trees go in the other neighbor's yard, or my leaves, right? But all land uses have externalities. And so again, it's that balance. Now, non-participating landowners, they've made a decision not to participate in that project. And they have a right to make that decision, and they should be protected in that decision. But sort of protecting landowners from themselves, participating landowners, in a very paternalistic way, to me seems really unfair, and it goes beyond that minimum intrusion into private property rights that I talked about at the beginning. Property lines and residences, also a very important distinction, especially for wind energy, but solar also. A lot of it happens in very rural areas where there's not a residence anywhere near a property line. But you see regulations that are setbacks from property lines, like there's a residence right up against that property line. Again, those regulations go beyond that minimum intrusion, and they don't have that why to them. Why are we protecting that property line? Right? Think about that. Now, there's some reasons to do that, but it's very different than the reasons and the ways in which you might protect a residence from a neighboring land use. Again, balance the interests of the community, so that's at least 4 slides with the word balance on it. Property rights, right? If I don't want to participate in a wind project, I shouldn't have to. But I should also recognize the property tax benefits, the economic development benefits, and the benefits of a diverse energy supply. Treat all land uses similarly. Again, the things I've talked about to this point, this is sort of an application of those. You see some communities where they have a very high noise standard for industrial facilities and a much lower noise standard for wind turbines. Well, why is that, right? Does that make any sense? Is that fair? Are we treating similar land uses similarly? And that's it. I'll turn it over to Bill, and then I think we'll do Q&A at the end. So thank you.